to Ms. Meek, my follow-up question for you is, you've been through a series of deployments and change of location, right? Change of residence as a result. Typically speaking, because we know there's some bases in closer or further proximity to maybe the county courthouse, for a member of the military who's reassigned, moves, and then has to re-register or chooses to re-register, how typically easy or difficult is it to be able to leave the base during county office hours to go and re-register to vote in person with the proper paperwork? Is that something easily done or kind of hard?
Thank you for that question. Maybe it should go without saying, but I guess it needs to be said. It would be very difficult for that to happen. As you can imagine, that it would be costly. Like, would we be required to travel at our own expense? Would military members be allotted leave simultaneously to all travel back at the same time to be able to re-register? The reality is that most military families don't have the means to do that, and to be able, if you're required to produce those documents in person, it would be a severe barrier for military families and service members.
Thank you. I had a sense, but it's better for the record to hear it from somebody like you as opposed to from somebody like me. Now, continuing with our theme of looking at specific impacts of the SAVE Act in different voter groups, whether it's women who chose to change their name when they got married or members of the military. Another community that can be significantly impacted are Native American voters. Now there's Native American communities throughout the country, and in many cases, these voters already experience difficulties with voting due to lack of available resources or the great distances that they have to travel to get to a county courthouse to update their registration or to submit their ballot. To make matters worse, the SAVE Act actually, and Trump executive's order for that matter, stipulates that nearly all tribal IDs would not be acceptable forms of identification for purposes of registering to vote, as they do not show citizenship status. That's why, together with Senators Schatz and Wyden, I led my Democratic colleagues in a letter to the Department of Interior, Secretary Burgum, demanding he stand up for their voting rights and to work with tribal communities to improve election administration, not make it more difficult. Back to Secretary Simon, you're from a state that has a sizable Native population. Can you talk about the voting experiences of Native communities today and the impacts the SAVE Act would have on them?
Yes, thank you, Senator. We have 11 federally recognized Native American tribes in Minnesota. I regularly meet with their top executives, and they are all over the state of Minnesota. And there are at least a couple of things that come to mind that would be exacerbated by the SAVE Act. One is the fact that when you're talking about birth certificates, a not insignificant percentage of Native Americans in Minnesota, particularly of a certain age, do not have a conventional birth certificate of the kind that would be accepted as proof here. That's a problem in and of itself, and that's a shocking one, and one that should give us all pause. The other issue in Minnesota, and I gather other states as well, but I can speak to Minnesota in particular, is geography. So because this would require someone to go physically to a place to register to vote, to show certain papers, that can be a real hardship, or at the very least an inconvenience for Native communities. I'll give you one example that comes to mind. In Lake County, Minnesota, which is in the northeast part of our state, we have members of the Boys Fort tribe. Depending on where you live at the reservation, it could be more than 2 hours each way. That's 4 hours round trip to get to the county seat where you would need to provide in person that proof of documentation. That, no matter who you are or where you come from in Minnesota or anywhere in America, is too much to ask. That is a real burden on someone, and that is a burden that would fall disproportionately on those who live on Indian lands or reservations in Minnesota on Native American communities. So those are two things in particular that stand out to me that would be a stressor and inconvenience, but really suppressive in nature in the real world.
Great, thank you. Mr. Logan, you, the registrar recorder for the most populous county in America, but you just finished a term as president of the California Association of Clerks and Elections Officials. Can you speak to the California experience, whether it's the challenges that this would bring on tribal voters in California, and on the flip side, some examples of what you're doing in Los Angeles County or what California is doing to facilitate voter participation amongst Native voters?
Yeah, thank you, Senator. And I will associate my remarks with Secretary Simon's very similar situation. California is home to over 100 federally recognized tribes, and that represents over 700,000 people. And we know that nationally, this is already a population that is underrepresented in voter registration in its existing form, and the additional barriers associated with the SAVE Act, for all of the reasons Secretary Simon mentioned, that most of these reservations are in rural areas. They're a significant distance where people would have to travel in order to bring the documentation. And then there is the issue of what is the qualifying documentation and whether or not they would have access to qualifying documentation. Many of our residents of the reservations also have non-traditional mailing addresses, so matching an address to the registration record can be a challenge as well. And so, similar to the Secretary, I'll give the example of the Yurok tribe in Northern California, which is in Humboldt County, but to travel from the reservation to the Humboldt County seat, similar to the example we heard from Secretary Simon, is estimated to be about 2 hours and 40-minute drive just to come to the county seat in order to provide that documentation, and then to not know whether or not the documentation that you have is actually going to be acceptable is particularly burdensome. As far as California, I think we're very proud in California, and much of this associated with the work that you led as Secretary of State and the collaboration with election officials, that we provide a voting model that recognizes the diversity of our communities, and that voters need options to vote that are relevant to their circumstance. So we have a voting period where you can vote in person over up to 11 days during an election. And then we also provide vote-by-mail ballots to all registered voters, and registered voters exercise multiple options for returning those vote-by-mail ballots. We know from the 2024 election that the majority of our voters in LA County, over half of those who use their vote-by-mail ballot, return those ballots, and the convenience of a very long ballot, being able to go through all of the measures and contests at home, and then to choose the option for submitting that ballot that gives them the confidence that their vote is going to be cast as and counted as they intended.
Thank you. Now, we've spent a lot of time thus far talking about the SAVE Act in particular. In my opening remarks, I acknowledged both the SAVE Act as a threat, but also the executive order signed by President Trump a couple of months ago. Within days of President Trump's issuance of Executive Order 14248, entitled Preserving and Protecting the Integrity of American Elections, just using his official title, voting rights groups in states across the country quickly sprung into action, filing lawsuits to challenge this unprecedented effort to control states' election administration. In addition to attorneys general from 19 states, grassroots organizations representing broad swaths of impacted voters recognized the paragraph for what it was, unlawful. And the District of Columbia District Court agreed, granting the group's motion for preliminary injunctions on 2 sections of the executive order, which then blocked the executive order's requirement imposing documentary proof of citizenship for the federal registration form, and another requirement to verify citizenship for folks registering at public assistance agencies. By the way, that's a federal mandate for states to offer voter registration opportunities through their Department of Motor Vehicles and at least one other public assistance agency. Question for Mr. Proano and Ms. Stewart. Can you briefly discuss what most concerned you about the executive order and what motivated your respective organizations to participate in these lawsuits?
Thank you, Senator Padilla. We're very proud to have actually filed this lawsuit in partnership with Native women voters. Trump's executive order, if enforced, would unilaterally strip away longstanding voter protections.
Your microphone, please.
Thank you. Trump's executive order, if enforced, would unilaterally strip away longstanding voter protections. Voting rights are the bedrock of Latino civil rights and equal protections. And like the SAVE Act, the executive order appears to have been motivated by fear for an increasingly Latino electorate and it threatens to disenfranchise millions of eligible voters.
So for definitely, we felt like we had to file a lawsuit because of, one, the mirroring of the SAVE Act, which we were already in opposition of, but also, have to be a little careful since this is active litigation. We have gotten a positive PI motion on in our favor, but this is still active litigation. So I just want to mention that and just be a little careful in terms of how I'm talking about it. But it was really important, this lawsuit, because a lot of organizations who do voter registration, who are out in communities doing this work, are part of this lawsuit. And I just want to mention NAACP. We have legal partners, some of which may be in the room, Brennan Center, ACLU, LDF, and others, because of how egregious this is and how much it would affect not only women voters, but anyone who is in a marginalized community. And so while we recognize that the executive order is an executive overreach and just doesn't have the authority to do that, we still have to fight it to ensure that it does not get implemented. And so we are fighting on double fronts here, not only in the courts, but also, showing up to hearings like this to make sure people understand how dangerous this is. And so I will just say that it was not a question or an option to not file a lawsuit because of the danger that it had.
Thank you both. And I'll respect that it is active litigation. We'll pry into too many details here because I wouldn't want to compromise the prospects of a favorable outcome. I understand that while I was away, questions came up for Secretary Simon and Mr. Logan on the costs of implementation of what the SAVE Act calls for, what the executive order calls for in your respective jurisdictions. Not sure if the general conversation of the need for additional and more consistent support for election administration came up. If it did, is there anything you'd like to add? And if it didn't, would you like to speak to, just remember my Secretary of State days, a small infusion every 7 years, we'll take it, but we need much better support for elections administration across the country than that. Mr. Secretary.
Well, thank you, Senator. And this is an issue that you and I collaborated on when we were colleagues as Secretary of State. And I'll just put an exclamation point on what I said earlier. We are truly grateful. I think I can speak for all states. We are really grateful for the periodic provision of funding under the Help America Vote Act. It's critical. It's vital. It's done us a lot of good when it comes to election security. That said, and not taking anything away from our gratitude, a more reliable, dependable pace or interval would be much, much appreciated because we really don't know how to plan. We don't know how and to what extent to conserve those resources. Are they meant to last us 2 years or 6 years or 10 years? We in Minnesota have been quite cautious and strategic about the use of that money. It's always a case of hope for the best but plan for the worst. And the worst is that we might not get the money for a while, but that consistency of the interval and the amount as well, but really, principally, speaking only for myself, the interval is crucial because that allows us to plan and be even more strategic about how we deploy that money. But it's a great partnership. We very much appreciate the funds, but that consistency would go a long way.
Mr. Logan.
Yeah, thank you for bringing up this topic, a critical topic, because it's really the compounding effect of the loss of what remaining federal funding has been available to trickle down to the local level for things like cybersecurity support, election security, physical security support, accessibility, et cetera, which seems to be drying up. And that's what we've been relying on to ensure, and I think significantly contributed to the success of the 2020 and 2024 elections. And now, in order to maintain those programs, those successful programs that were put in place in 2020 and 2024, local government is going to have to make up for the loss of those funds. If we layer then on top of that the provisions of the executive order or the SAVE Act, and there's no funding associated with that, you're going to see jurisdictions that are going to have to make really unfortunate choices about not funding security or not funding voting options, and nobody wants to be in that situation. The last thing I'll mention, and I think this is a part of the executive order that is not getting as much attention yet, but I think will in the coming months, is if we face a situation where the voting system standards are changed in the country, even though those are voluntary voting system standards that place jurisdictions in a position of having to modify or replace voting equipment. That's not something that can be done in a short period of time, or shouldn't be done in a short period of time, and it's incredibly costly. In our jurisdiction alone, we have 31,000 pieces of equipment that potentially, depending on the interpretation of the provisions in that order, could require modification or replacement. Those are valued at $140 million, and we don't have a funding source to do that. Fortunately, we don't believe that that's necessary. We think that it's good equipment and it's functioning quite well, but it's concerning to have that on the table at this time.
Thank you both for that. Just for context on the funding front, in fiscal year 2018, Congress allocated $380 million for election security grants. That was a welcome amount at the time, I recall. In this year's spending bills, we appropriated just $15 million. So it took a long time to get, and it's not much this go around. So let the record reflect that my Democratic colleagues and I are calling for no less than $400 million in the next year's spending plan. So we'll have to work together to advocate for that appropriation when the time comes. Want to move on. We've talked a little bit about the impact of the SAVE Act and the executive order on election administration. We've talked about the impact on voters from a participation standpoint. But one of the things that has been overlooked in recent weeks in this debate is the sensitivity of our voter data and what the executive order threatens. The president's executive order on election empowers DOJ, we've all heard of DOJ by now, to review state voter lists and directs the head of the Social Security Administration to share information under the guise of voter eligibility. I recall as California Secretary of State during the first Trump administration, not just I, but another 43 states, their secretaries of state, both Republican and Democrat, rejecting demands from the Trump administration for sensitive private voter information that they claim to need to investigate their unfounded claims of voter fraud. Now, these directives should be regarded with suspicion, particularly in light of last week's reporting in the Washington Post that DOJ is, quote, racing to build a single centralized database with vast troves of personal information about millions of United States citizens and residents, end quote. Back to Secretary Simon. Can you discuss the procedures states already follow to confirm voter eligibility and the importance of multi-state partnerships to maintain accurate voter lists?
Thank you, Senator. And as you know from your experience as Secretary of State, Minnesota is not so different from California or other states in this regard. We have a robust system by which presently, right now, we screen and filter all voter registrations. So, for example, we subscribe to multiple death databases. I know that's a glum subject, but we have the Social Security Death Index. The Minnesota Department of Health also has a death index. We work with our Department of Public Safety. We work with our judicial branch in Minnesota and the federal courts as well, Social Security Administration, the U.S. Postal Service, of course, with National Change of Address data. And then there's something that was embedded in your question that I want to emphasize. Minnesota is a member of what's known as ERIC, which is the Election Registration Information Center, and it is now at 26 states. A few have left recently, but it is a robust system by which we exchange anonymized data to determine the presence of people registered to vote, usually inadvertently, in multiple states, and on rare occasions, people who attempt to vote in more than one jurisdiction. Now, that's rare, but we can catch it because we exchange data. So Minnesota is not so different from other states in that regard. We already have robust systems in place in terms of data. And Senator, I served alongside you as Secretary of State during the first Trump administration when many states said no to a request for personal data. I can say in Minnesota, voters are particularly attentive to that issue. We're one of the dwindling number of states that does not have party registration. And one of the reasons, in my assessment anyway, over the years, is Minnesotans are really wary of disclosing even that information to a government entity. So it's an issue, voter privacy and data privacy, which is a prominent one in Minnesota in particular.
Appreciate the state perspective. Mr. Logan, what would it mean for a local jurisdiction to have to collect this personal data? I mean, are you equipped to not just collect, but maintain safely and securely this sensitive information?
Thank you, Senator. I think that that your question sets up the kind of double-edged sword of this part of the act. On again, echoing Secretary Simon, California's laws fiercely protect personal privacy, as you well know, and we're actually one of the few states where voter registration data itself is not public record. It's open for electoral purposes, academic purposes, et cetera, but it is not easily shared for commercial purposes and for database matching, such as is proposed in the order. Yet, on the flip side, the order implies that offices like mine would be collecting documentation and maintaining documentation that has personal identifying information on it that it is not even needed for voter registration. And so it puts us in a position of also making sure that what are our retention guidelines, what are our legal risks for disclosure or breach of that kind of information, how long do we maintain that, how do we destroy that information when it's no longer relevant? Those are all questions that would need to be answered if this were to become law.
Thank you both. We mentioned in passing a little bit from a cost standpoint of the decertification of voting systems called for by the executive order. Beyond just the cost, can either or both of you shed just a little bit more light on the challenges to comply with that element of the executive order if it were to be upheld?
Thank you. I will just say that the challenges include both time frame and also capacity. The voting systems market in the United States is very limited. There's only a few companies that provide equipment. It's one of the reasons that we developed and implemented a publicly owned voting system in Los Angeles County. But the current version of the voting system guidelines that are adopted by the Election Assistance Commission at the federal level, there are no systems in the United States that have been certified to those standards, and there are only a few systems that are currently in development and even going through testing for that level of standards. So if there were to be a change in the voting system standards now, before the 26 election or even the 28 election, it would be very challenging for the market to respond to that and very challenging for jurisdictions to manage the change management side of that. And then the final element of that I would mention, as you well know, with going through a major change in voting system in a jurisdiction, you can't underestimate the importance of an investment in public outreach and voter education. You can have the best system available, but if voters don't know how to use it and are not comfortable with it, that transition is not going to go well. And so that, in addition to the funding for the modification, the replacement, the limitation in the market, we also need to address the funding gap for outreach and education.
I don't know if I can add that much to Mr. Logan's excellent summary there, except to say that the cost of replacing everything in Minnesota would be, we estimate, about $30 million. That cost would be borne by local governments, not by the state of Minnesota. And just a note of perspective that I would add is the second generation of voluntary voting standards that Mr. Logan alluded to took the better part of a decade to develop. So this isn't something that can be done like switching a light switch on. This is really intensive, time-intensive work that takes a long, long time. It's all about what runway do you have to prepare. I said earlier in my testimony, and this is a theme running throughout, I think, the SAVE Act is effective immediately upon enactment. That means things would literally change overnight in America when it comes to election administration. And it's that way of thinking that I think really seriously overlooks and does a disservice to the challenges of administering elections.